Hi, I'm Palmer Johnson. I'm a Tulsa divorce attorney, and welcome to my video series where I answer frequently asked questions I get from clients about family law issues. And today I am talking about prenuptial agreements and specifically what is the difference in the divorce process if you have a prenuptial agreement. And I would say that in some regards the process is going to be very similar to what it would be without prenuptial agreement, with one large exception, that if you have a valid prenuptial agreement, then the court's only going to be dividing the marital assets that were obtained during the marriage. They're going to equitably divide the marital estate, which could be the increase in value of property that was brought in separately to the marriage. In other words, perhaps there's equity. Maybe there was $100,000 in an investment account, and 10 years later, there's $800,000 in that investment account. So potentially, that growth could be a marital asset that the court might need to divide up between the parties. Additionally, you're going to be looking at things like the controlling law. Where was the prenuptial agreement executed? What did the parties intend to be the controlling law? If it was done in Oklahoma and Oklahoma law is going to control that agreement, then you could be looking at some enforceability, depending on which side of the equation you're approaching the agreement, if you're attacking it or if you're seeking to enforce it. And as a general rule, things that are going to ensure that you have a validly enforceable prenuptial agreement are going to be things that happened at the time that the agreement's entered into, essentially like any contract, that there's a fair and complete disclosure of the other person's assets, that the other person wasn't asked to sign the document under duress, meaning on the steps of the courthouse. You picture the bride in the church getting ready for the wedding, and all of a sudden her groom's attorney comes in and says, "I need you to sign this document." Things like that would be very problematic for the enforceability of the document later. And if you signed a prenuptial agreement under circumstances like that, then I think you would clearly potentially have a valid grounds to attack it. But um, let's assume that both parties disclosed all of their assets, that the agreement itself is fair on its face and provides something for both spouses. In the event of a divorce, what you would be asking the court to do is to enforce the contract that was entered into, which could very much streamline the property um, settlement portion of the divorce decree and prevent the need for a trial to allow the court to decide those issues, because it's going to be somewhat predetermined what's going to happen. And this would be particularly important to somebody who perhaps owns a business or significant property going into a marriage that they have defined as separate and intend to maintain its identity as separate property, and they've taken very specific steps to do that. Things that are not going to be included in a prenuptial agreement or considered enforceable would be perhaps provisions about child custody. Um, there could be a provision in a prenuptial agreement concerning alimony or spousal support. However, courts have said those agreements need to be looked at the time of divorce, where as um, the property portion of the prenuptial agreement is going to be looked at the time of the agreement. The reason why you would look at the support portion at the time of the divorce is that there's still going to be the need and ability to pay of the other party that the court's going to have to consider in making spousal support awards. So um, to kind of sum that up, the process should potentially be streamlined, but there absolutely may be plenty of things that still need to be litigated. Child custody is not going to be something that you're going to have included in your prenuptial agreement, and you're still going to have to either come to an agreement or have the court decide what's in the child's best interest. So while it can help streamline the process, it may not completely avoid the need for litigation, and certainly won't um, prevent you from needing independent counsel and help to ensure that all of your rights are protected. If you are uh, in the process of getting a divorce or considering a divorce and you've got a prenuptial agreement, I'd be happy to consult with you about that and provide you with more direction on your specific case. I can be reached at moms.law and would look forward to setting up a low-cost consultation with you to talk to you about how I could help protect your rights and make sure that you uh, aren't aren't subject to an unfair or unenforceable prenuptial agreement, or conversely, that the other side isn't able to attack your valid prenuptial agreement.